Thank you, Malaka. Thank you all for coming. Clearly, you all have some idea of the rapidly changing framework that we're living in here in the United States with September 11, so I won't take up too much of your time, except to say that September 11, 2001 was the first day of my professional career at Hampshire College. I was scheduled to teach at 8 a.m. that day, actually 9 a.m. that day, when the news hit that the World Trade Center was attacked, and that a number of people had died, and there were flames. And so in a way it marks both my political career, my intellectual career, and much of my concerns today. I'm also a writer for a political journalist for Salon.com, and one of the pieces that I wrote last week as I began the semester was about one of my classes, where I had put a bunch of names on the board. The names of Trayvon Martin, the names of Yusuf Salaam, Afia Siddiqui, Shakir Amir, and Jose Padilla. And my students were very familiar because they're very politically active. In fact, there are a couple of them here tonight. Generally the students of Hampshire are very politically active, politically concerned, and hope to spend the rest of their lives fighting racism and injustice. And yet they didn't know the names of these last three that I put on the board. And it struck me that there is a way in which we can talk about all kinds of social injustices, and yet 9/11, the war on terror, is so close to them, and yet not close enough in a way, so that they know it's here, they know that something happened, and yet they're not quite sure what kinds of questions to ask, or even how to take a step back to see what kind of world we might have envisioned, what kind of world we might have lived in prior to September 11. And it really did change many, many principles that I think I had grown accustomed to here in the United States. And I think our distinguished panelists have plenty to say about that. So please join me in welcoming them to Let's Have a Conversation.
Good evening. Much of what I'm going to cover you can find either at acluct.org in our Privacy Rights Guide, which is a free download, or at the aclu.org, where you can read the papers and the cases and the advocacy I'm going to describe. I'm going to give a brief history, sort of a brief legal history, leading up to the disclosures in June in the Greenwald pieces, and then talk about what the ACLU and others, what we're doing about those disclosures. But in order to understand those disclosures, you need some legal background. Whether we're talking about electronic eavesdropping or wiretapping, the law in the U.S. under our Constitution is clear. If it violates an actual and reasonable expectation of privacy, it's a search. And searches under the Fourth Amendment require warrants, except in very limited, narrowly drawn exceptions. Since 1967, these have been the constitutional requirements for domestic wiretapping. The warrant must be issued by a neutral and detached authority to determine that there's probable cause. The applicant for the warrant must say what the crime is suspected, where he'd like to search, and whom or what he'd like to seize, or what conversations they'd like to hear. The order has to say when the wiretap will stop, there has to be notice or some reason why it can't be given, and there has to be a return. This analysis applies to all electronic eavesdropping, wiretapping, and bugging in the United States under the law. Several laws specifically addressing spying on foreign powers and suspected terrorists have amended the Wiretap Act. When the Supreme Court held in the late 60s that warrants are required in cases of domestic threats to national security, it left open the possibility that warrants might not be needed for foreign threats. The president jumped on this opening and began a huge program of eavesdropping. But after investigation, the Congress perceived that the executive branch had abused the power. So in 1978, it enacted the Foreign Intelligence Surveillance Act, FISA. The law required court orders, sometimes called FISA warrants, for wire and radio eavesdropping within the United States. The orders issued from a special court, the so-called secret FISA court, composed of judges from the judicial branch and of the federal government. And there's another special secret court for reviewing decisions of the FISA court. If the target of the surveillance is an alien in the United States, the order issues on probable cause that he was a foreign agent. But if the target is a citizen or permanent resident, there must be probable cause to suspect criminal activity. There must also be probable cause that the target will actually use the device monitored, a statement that there is no other way to get the information, and attempts to minimize the intrusion. Exceptions permit unapproved taps for short time during war and when the Attorney General determines an emergency demands it. That's the backdrop for the United States Patriot Act. After the September 11, 2001 attacks, Congress passed the Uniting and Strengthening America by providing appropriate tools required to intercept and obstruct terrorism Act of 2001. That's the full name of the Patriot Act. And the Intelligence Reform and Terrorism Prevention Act of 2004, two measures that began as temporary laws but have been extended ever since. Together, these laws amended the Foreign Intelligence Surveillance Act to include terrorists as foreign powers, even if the terrorist is acting on his or her own, the so-called lone wolf. And they currently provide for federal authorities to seek roving wiretaps. And as I go through this part, pay attention to how this is very different from what the Fourth Amendment requires. So-called roving wiretaps, which target a person and not a location or a particular device, to be supervised by the Foreign Intelligence Surveillance Court and without notice that would be required under the Wiretap Act. They also permit authorities to issue national security letters demanding access to records of all kinds, including travel records, pharmacy records, and phone records, all the while forbidding the recipient of the letter from tipping off the subject of the request. Although these gag orders have been held unconstitutional, in part based on a case here in Connecticut where librarians very bravely did not comply with that gag order, and the ACLU represented them in that challenge. Warrantless searches conducted in the name of national security ever since September 11, 2001 terrorist attacks began under a classified program by the National Security Agency and was kept secret from the public until 2005, when the New York Times reported for the first time that the NSA was eavesdropping on thousands of Americans, all without warrants or authorization from Congress. The program began as an unchecked exercise of presidential power. Sound familiar? It's history repeating itself. Relying at first on his legal staff's broad interpretation of executive authority, the president seized on language in a 40-year-old Supreme Court case to justify acting without warrants. As he saw it, the court in 1972 held that wiretaps and bugging for domestic security threats required warrants but left open the question of foreign threats. When the NSA spying program became public, however, the president no longer relied solely on his own branch's inherent authority, but invoked also Congress's broad-granted power to use military force in response to the attacks. And this continued until at least 2007, when the government claimed that the original program of spying had stopped. But it didn't really stop, for while some members of Congress were appalled, others saw a way to approve the program after the fact and therefore passed the FISA Amendments Act of 2008 to modify the Foreign Intelligence Surveillance Act. Now, the current president continues to run a program of NSA data mining without warrants on the theory that he needs no warrants so long as the target is out of the country and not a citizen or permanent resident, even if that means listening in on a U.S. citizen on this end of the line. Now, with respect to the FISA amendments, when it became clear that the NSA data mining exceeded even the USA Patriot Act, Congress passed this new law requiring the Attorney General and the Director of National Intelligence to apply to the FISA court for an order to conduct surveillance on aliens abroad without any need for probable cause that the target is a foreign power or its agent. The law doesn't require the government to say what facilities it will target and allows unlimited surveillance for up to a year. While officials may not use the law intentionally to target a United States citizen or permanent resident or anyone in the United States, apparently they may incidentally eavesdrop on such a person without a warrant. And even though it has been condemned for its relaxation of the standards for obtaining a warrant and the limits it places on judicial supervision, this law has just been renewed for an additional 5 years. Up until the Greenwald story, we, meaning the ACLU and other groups concerned about these troubling sets of laws and the way that we thought they were being used, we did not have information about the extent of the spying. Because we had been told by the Supreme Court of the United States that we had no standing to sue to discover the extent of the spying, because we could not prove that we had been spied upon by the government. So, an effort to challenge the original program of spying hit a snag on the principle of standing, which is the doctrine that says to bring a challenge in federal court, you must have suffered an actual injury. And the appeals court held that because we couldn't determine that we had been monitored, we couldn't claim that we were injured by the program. And the Supreme Court reached the same conclusion in a case in 2008. The bad news from the Greenwald disclosures is the extent of the spying. The good news is that we now have standing to challenge the spying, because it's clear that as Verizon business customers, the ACLU, National Organization, and New York Civil Liberties Union together have standing to challenge the NSA program of spying. And before I delve into the cases that have been filed to challenge the spying, I'm going to outline briefly what we learned from the disclosures. And I'm going to take this directly from testimony by the ACLU in the Senate Judiciary Committee. On June 5, 2013, The Guardian disclosed a previously secret foreign intelligence surveillance court order that compels a Verizon subsidiary, Verizon Business Network Services, to supply the government with records relating to every phone call placed on its network between April 25, 2013 and July 19, 2013. The order directs Verizon, I'll refer to it, to produce to the NSA on an ongoing daily basis all call detailed records, or what's referred to as telephony metadata, relating to its customers' calls, including those wholly within the United States. As many have noted, the order is breathtaking in its scope. It is as if the government had seized every American's address book, with annotations detailing which contacts she spoke to, when she spoke with them, for how long, and possibly from which locations. News reports since the disclosure of this order indicate that the mass acquisitions of Americans' call details extends beyond customers of Verizon, encompassing subscribers of the 3 largest telephone companies. And members of the Congressional Intelligence Committees have confirmed that this order is part of a broader program under which the government has been collecting telephone records, essentially of all Americans, for at least 7 years. Intelligence officials collecting have said that the government does not indiscriminately sift through the phone record database. Instead, it queries the database only when there is reasonable suspicion, it says, based on specific and articulated facts that an identifier is associated with specific foreign terrorist organizations. According to a statement released by the government, less than 300 unique identifiers met the standard, and queried. Keep in mind, 300 unique identifiers is 300 people. But in evaluating that number, you have to realize that these searches implicated the privacy of millions of Americans, despite this 300 number. Intelligence officials have explained that analysts are permitted to examine all call records of all individuals within 3 so-called hops of a specific target. As a result, a query, one of those 300, yields information not only about the individual thought to be associated with a specific foreign terrorist organization, but about all of those separated from that individual by 1, 2, or 3 degrees. Even if one assumes conservatively that each person has an average of 40 contacts, an analyst who accessed the records of everyone within 3 hops of an initial target would have accessed records concerning more than 2 million people. Multiply that figure by the 300 phone numbers the NSA says that it queried or searched in 2012. And by the 7 years the program has inherently been in place. And one can quickly see how official efforts to characterize the extent and impact of this program are deeply misleading. The other deeply troubling aspect to this spying is the data compilation. From what is known so far about NSA procedures, they permit the NSA to collect international communications, including American communications, in bulk, retain even purely domestic communications, and the retain part is important. Collect and retain communications protected by attorney-client privilege, maintain knowledge databases containing sensitive information about Americans, and retain encrypted communications indefinitely. There is reportedly so much data that there's an NSA warehouse for it somewhere. What's worse, because of the collection's secretive nature, no one knows what controls there are on the data, if any. It has been reported that efforts to render the data anonymous and to limit who can see the data, that these efforts have failed, as have efforts to ensure that the program follows even its author's own broad interpretation of executive power under the Fourth Amendment. So, that's the history of the spying. That's a little bit of the detail of what has been learned from the disclosures. And so I'm going to close with, I wouldn't say hopeful, but at least efforts that we're pursuing to try to figure out what to do about this. First, the ACLU, with others, pursued a motion in the FISA court immediately. It was June 12th or something like that. They filed a motion to pursue opinions, to obtain copies of opinions issued by that secret court regarding the business records provision in the FISA amendments. And on September 13th, 2013, we obtained an order from the FISA court that the government has to produce a list of the opinions and a timetable for declassifying and redacting those opinions. And he also found that we had standing. We were working with the group at Yale, the DC affiliate and the national organization, and the DC affiliate and national had standing. The media group at Yale did not. But nonetheless, we have an order, and we're hoping to get these opinions so we know what has been going on further under this program. The second thing that the ACLU did with NYCLU is sued in the Southern District of New York for violations of our constitutional rights by the NSA spying and compilation of data of almost every telephone user in the country, the telephony metadata. And it's on the basis of being Verizon business subscribers who claim that the surveillance of our communication violates the Patriot Act and also the First and Fourth Amendments. The government has, well, first of all, the plaintiffs in that case last month filed a motion for preliminary injunction to direct the government to quarantine all of this metadata and to bar the government from searching the metadata. And the government, not surprisingly, has filed a motion to dismiss, and both motions motion for preliminary injunction, and the motion to dismiss are scheduled to be heard in the Southern District of New York in November. I believe it's November 1st, but I'll have to double check that. And I'll conclude with a list of amicus briefs in support of the plaintiffs in that case, where they came from. One brief came from former members of the Church Committee, which was the committee in Congress to investigate the misuse of the early version of the statute in the 70s. And on that committee and on that brief are both Walter Mondale and Gary Hart, and a long, long list of law professors. The Reporters Committee for Freedom of the Press and 18 media organizations filed a brief. The National Rifle Association supported the ACLU with an amicus brief. Congressman Sensenbrenner, represented by the Electronic Freedom Foundation, and you might be interested in this professor, a philosopher, Michael Lynch, submitted an amicus brief just last week outlining on a philosophical basis why privacy is important to us as human beings, and the PEN American Center. And finally, the quote that I gave you, analyzing the metadata, comes from our legislative advocacy. Our director of our center, Jamil Jaffer, testified before the Senate Judiciary Committee and will continue to work towards restrictions on the spying program in Congress. But the track record there by members of Congress, despite the shock and outrage, has not been very good. So that's my part of the program. I hope it wasn't too basic or too complicated, but I think it's important for everybody to understand.